May please, your lordship. With regard to item number 4, your lordship,
Why
instruction to withdraw the writ appeal. Your lordship.
withdraw or
Yes, your lordship.
appellant counsel for the appellant craves liberty to withdraw the writ appeal, hence the same is disposed of as withdrawn.
Much obliged, your lordship.
Okay.
May it please your lordship. Lordship, in item number 15, we have filed a affidavit in reply for today. Lordship, may we be requisition?
Call the.
Much obliged,
Well,
Lordship.
an additional affidavit has been filed by us also.
You also filed.
We have filed the affidavit, but some documents are left out. I am filing the additional affidavit, bringing it on record.
So what do you want?
Maybe allowed to bring on record.
Bring it on.
Much obliged, Lord.
Mhm.
My lord, in item number 10, my lord,
Mhm.
I have filed my affidavit in opposition, my lord. I may be called for the same now.
Yes, sure, sure.
Wait, please, Lordship. Lordship, we have filed rejoinder affidavit in item number 15. Lord. We are allowed to come on record.
Somebody already made a request
Lordship, another, we have also filed in.
or get.
Daily list for orders item 6.
What is to be done, Mr. KL? Nothing. The matters are squarely covered against you.
Yes, Lordship. That is,
So-
no, Lordship, regarding notice, Lordship. Regarding notice was written answer.
The law is well against
No,
you.
Lordship.
Settled 2011 judgment.
No, Lordship.
That is,
Lordship, your Lordship has passed order in a bunch of cases. They directed the department to reimburse the interest part. That will be subject to the outcome of the SLP 20 before the.
SLP, Dharampal Satyapal.
Yes,
So same order we'll do here.
but regarding notice, Lordship.
What difference does it make?
Not
Same, can we pass on any order? But Dharampal Satyapal, what you will do? 2011 judgment,
2000.
then Supreme Court, then it has been followed in 2016. Dharampal Satyapal will meet the same fate.
Lordship, let,
It is bound to, Mr. KL, you very well know.
no, Lordship, subject to the outcome of bill.
All right. Pass on that judgment.
Lordship,
Dispose of.
at present, it is not with me. I'll supply.
Give me the number. Give us the number, please.
I'll
Yes.
provide a number, Lordship. I'll provide the number.
Disposed of. The refund of interest from the late payment of itself refund. So we have already decided that they are banking upon some dependency of execution. But the law is otherwise, there are numerous judgments of which have already decided the issue. If there is a delay, then they are. What is to? Yes.
Item number 7.
Please, Lordship. My lord, in this matter, my lord, we are taking steps by today itself, Lordship.
Then counsel Mr. Sharma appearing for the department. Praise for and is granted. Last opportunity of 3 days to take steps for effecting service on the respondent. If steps are taken, let process be issued to the respondent. However, on failure to do so, the appeal shall be dismissed for want of prosecution without further reference to it.
Deeply applied.
Peremptory order.
Item number 8.
Very sorry, my lord. Last occasion, my lord, the matter was called, my lord, it was present, my lord. Accept my notice, honestly speaking, accept my notice, my lord.
Except
Accept my notice, my lord. I'm very sorry, my lord. I could not, although I have filed application for listing the matter. Matter was heard by your lordship on 25/1/2023. The matter was not listed there, sir. So filed the application on 2. And third was matter was listed, my lord. I'm very sorry that it was not present.
we listed the matter on your request, then you don't turn up. What is to be done?
No, that nothing happened. But next day, you look.
Then we'll impose cost for restoration. Let it go to the Bar Association. How much, what is your offer? Tell us, please.
Well, after your lordship.
No, we are asking you. The amount will go to the Bar Association.
5,000, my lord.
10,000.
5,000.
Yes, Mr. Saikya.
Yes, I have no objection. I'm
Huh,
more than
you
happy.
should have asked for a raise. Huh, you have no interest in the Bar Association. All right, 10,000 cost restored. Cost to be deposited in the Bar Association.
And my lord, lordship, will fix the matter for hearing, my lord.
Yes, the matter will again come up for hearing.
No objection. Highly objection.
Item number 9.
this IA has been filed seeking with a prayer for condonation of 23 days, how much the delay? 25 days occasion in filing of the connected data appeal. Service has been effected on the respondents. No objection has been filed to the prayer for condonation, hence the application is allowed. The connected writ appeal shall be numbered and listed for admission.
Item number 10 and 11.
So in this case, there is an IA also filed. I am the appellant in one of the appeals, Lordship. So instead of taking up the matter in piecemeal basis on the basis for which Lordship the vacating petition has been filed, my prayer would be that Lordship may be pleased to fix this matter for
Read,
final decision at the earliest.
No, my lord, this is a bit of problem because
Another
this
is Miss-
matter is
second.
going on since so many years. now.
The license period has come to an end.
Yes.
Now what survives?
Everything survives because the notice, the terms of the tender was very clear.
Mm.
The terms of the tender will commence from the date of signing of the agreement.
When was the agreement signed?
Agreement was signed and immediately it was not given into effect also.
It was given
It was
effect.
not, it could not be because immediately there was an interference of the honorable court. Till date, Lordship, they have not started the earlier system was still continuing. So my case, I have a right to get the settlement because I am the valid tenderer.
So till date, you have not operated the
No,
license
I am-
at all.
No, no, Lordship.
Is
I-
that so?
I'll tell your lordship, my lord,
Hmm.
what has happened, my lord. Please kindly hear, my lord.
Yes.
What's
yes.
the matter, my lord?
Mm.
An NIT was floated in the year 2019.
The issue is regarding interpretation, whether the drug license
No.
should be for the particular
No,
area.
my lord, That's one aspect of matter where I will satisfy. The NIT was floated by the state in 2019 for a period of 2 years, which expires in 2021.
Yes.
Now, my lord, what has happened? Invited, lot of bidders were there, about 13, 14 bidders. They participated. I have to tell your lordship, they participate from other district. Now, whether it is under the rules, whether you can participate from other district, this is one in the merit of the case. Now, the terms and condition for a moment, if your lordship kindly see at page 62, kindly see at page 62 of the
Yes.
main writ petition.
Rate
my lord.
appeal then.
Writ appeal, my lord.
Yes.
Page 62.
Hmm.
Kindly see number 3, my lord. The selected pharmacy canteen vendor must have a valid general drug license. Schedule is Xerox copy of drug license must be attached. Lordship got it, my lord? So there is no restriction to as such that you have to, from another district cannot participate.
Right.
Now, my lord will kindly see this number 5
Hmm.
in page 62. The pharmacy canteens have rented for a period of 2 years. Terms shall be calculated from the
Mr. Das,
date of
Mr.
the.
Das,
Yes,
rather than wasting your energy on this,
yes.
we'll hear it on Thursday, come.
Yes. Thursday is on 16.
Yes, 17, 16, whatever you want to say, 21st, 22nd, we'll dispose it of. Matter, the finally we'll hear the matters. Whenever you say.
20%.
We are trying to lay our hands on more files.
Yes, this is also.
We're running out of,
So could it be on 7th of September?
No,
Lordship?
Long
this is
side, not so long.
Let it be on 21st.
let the matter, there's 2017 appeals.
Yes, 2000, my lord, 21st, my lord.
22nd, 22nd.
22nd, yes, all right.
Tuesday.
There is some urgency on the part of the
List
government.
the IAs along with the connected rate appeals, with the understanding that the rate appeals shall be heard finally.
My lord, agreement has not been given effect to, but there is a stay order which has been operated by division bench.
We'll decide the matter.
The core issue is whether the valid license is a license of that area or from another district.
No,
That is the
that's
core issue.
That is merit of the case, my lord.
That is the merit because
Yes.
ultimately Lordship is hearing.
If
it
you
for the
want that
final-
academic discussion, Mr. Das, then it'll be better over a cup of coffee in your chamber. If at all there are any chambers.
Today he had all the arms and ammunitions, Lordship.
Not all.
Highly obliged.
Deeply obliged.
22nd.
Item number 12.
Yes. This is a 2017 appeal. Who's there? Yes, Mr. Nayak, what is there in this appeal?
Lordship, here the petitioner is praying for regulation of his service, Lordship.
Ah.
He is a PRA employee, Lordship,
He is a
appointed by a panchayat, Lordship.
panchayat.
Yes, Lord.
Okay. And his appointment is not as per law.
No, Lordship.
Why is that so? The department is represented panchayat and you are for the panchayat
No,
department.
Lordship, I'm appearing for, he is appearing from.
Okay. Why do you say that it is not a regular appointment as per rules? All right, para 10. And there was a whole bunch of writ petitions. What happened in the other matters?
My lord, I'm so sorry, my lord, but a different set of standing councils were handling this particular matter. I have to reconstruct the entire file, my lord. I do not have the file with me at the moment.
Mr. Counsel, do you know there were a bunch of writ petitions which were decided by a common order?
Yes.
What is the fate of whether anyone else filed an appeal? The other petitioners?
My lord, at this moment, my lord, I have no information.
This is a basic question which everyone should be having a knowledge of. This is matter of 2017.
Yes, my lord.
Analogous writ appeals, if they have been filed, what is the fate?
Yes. My lord, in the meantime, my lord, my IA may be allowed and matter may be fixed after.
Your IA is for
For implement, my lord, of a new, my lord, respondent, as respondent number 7, because, my lord, the Gaon Panchayat, my lord, is already abolished, my lord, and included in a municipal area, my lord. So I have impleted the.
all right,
executive
interlocutory application filed by land counsel for the appellant to implead.
My lord, respond in place of respond number 7, my lord.
Yeah.
Paragraph 4, I have mentioned, my lord.
To substitute, it will not be implement then.
Yes, my lord.
To substitute. Where is the application?
My lord. Paragraph number 4 of my IM.
Implement for substituting the respondent number 7, original respondent number 7, Sonai Gaon Panchayat by Sonai Anchalik Panchayat,
Yes,
which is the new
yes, Anchalik Panchayat.
Sonai Anchalik Panchayat.
Yes,
In view of the subsequent development is accepted, the respondent number 7 is permitted to be substituted in the manner indicated above. Amended cost title in the original, in the writ appeal, be furnished within 3 days. Re-notify on 23rd. The registry shall find out, we on a perusal of the file of the writ appeal, we find that a bunch of writ petitions were decided by common order dated so and so, 7/6/2017. Which in itself was, which in turn was based on another common judgment and order dated 26/5/2017, rendered in a bunch of writ petitions led by WPC number 5135/2014. The registry shall find out the fate of, find out whether any other writ appeals were preferred against the judgment impugned in this writ appeal, as well as the judgment dated 26/5/2017, referred to supra. And if so, the fate thereof.
He was also one of the writ petitioners.
Who?
The present.
Of course, he is the writ petition. That is why he has come here. But there were a bunch of writ petitions. What happened in the others? The others also must have come. So if those writ appeals have been disposed of, the matter would not require much deliberation.
My lord, in paragraph 4 of the IA, I have mentioned the new respondents.
But you will have to file the amended cost title.
Obliged.
Yes. Re-notify on 24th August.
Item number 13.
Lordship, 13 and 14, Lordship, 2 members.
Yes. Acquisition matters.
Logic.
Hmm.
Acquisition by.
If. Yes.
By the act of 1964 logic.
Hmm. What is the status of the project?
The process has started, Lordship.
Land has not yet been acquired. Logic.
Land has not been acquired.
Now, there was a stay order now after the final disposal, Lordship. It is at the final stage now.
Hmm. All right. Argue.
Logic. Logic may come to the Act Logic 1964 Act Logic.
Some
Do number one.
land within bracket requisition and acquisition act 1964. This acquisition was started in which year?
About 1.5 years, last year, April, Lordship.
Can you let us know just prima facie why this acquisition has been undertaken in this Assam Act and not under the LAR?
No. We have the procedure, we are following the 1964 and the compensation 2013 Act.
Okay.
On affidavit, there's a specific stand we have taken. So there cannot be any grievance regarding the quantum of the
Quantum of
compensation.
compensation. All right. The procedure of 64 Act you follow.
Yes, Lordship. And that
What
is
is-
permissible under the 2015 office memorandum.
Hmm.
So it is simplifying the whole thing. It is benefiting the persons who are actually getting it.
It is do number one. Page 450.
Yes.
Lordship may come to the Act section 3. Lordship.
Section.
Power of requisition. Lordship.
Yes, please.
Lordship, if in the opinion of the state government or any person authorized in this behalf by the state government,
Hmm.
it is necessary so to do for maintaining supplies and service essential to the life of the community
Hmm.
or for providing proper facilities for accommodation,
Hmm.
transport, communication, irrigation, flood control, and anti-erosion measures,
Yes.
including embankment and drainage, or for providing land individually or in groups to landless, flood-affected or displaced persons,
Hmm.
or to a society registered under the Assam Cooperative Societies Act 1949,
Hmm.
or a company incorporated under the Companies Act 1956, formed for benefit and rehabilitation of landless, flood-affected or displaced persons,
Hmm.
or to provide land for the purpose of construction of border fencing and allied works, including border roads and checkposts connected therewith
Yes.
along Bangladesh border. The state government or the person so authorized as the case may be, may by order in writing requisition any land and may make such further orders as appear to it or to him to be necessary or expedient in connection with the requisition.
Yes.
Requisitioning.
Hmm.
So Lordship, this purpose for which they have taken, it is a company Lordship.
Hmm.
It is not a state Lordship.
Hmm.
So this purpose itself shows that
Company involved in what, sir?
Lordship, there share in the company Lordship that in the last part of the,
It is involved in what business? What is the trade of the company?
it's relating to oil Lordship, petroleum
Yes.
products.
And
Lordship.
oil is needed by whom?
It is a company Lordship.
Oil is needed by whom, Mr. Bhagwati?
Lordship, that is
Uh,
common people.
Will you be able to reach the court building without oil?
Lordship.
So then what is the meaning of proper facilities, service essential to the life of the community, maintaining supplies,
Of the community Lordship, of the local area,
maintaining supplies?
Lordship. For the benefit of the community Lordship, for the benefit of the community,
For
it
the
is
benefit
essential.
of all. And the other way of looking at it is for not for the benefit of anyone because of the global warming, but we can't help it. So there is no survival without fossil fuel as on date.
Lordship.
So in which part of section 3 it will not come?
Lordship.
Everything except for Bangladesh border, everything is covered, sir.
No, Lordship, these are specially, this act is specially made for the poor and needy Lordship.
Yes.
Suppose so for rehabilitation, etc. Lordship, flood affected people Lordship.
That is one part of it.
uh,
That is one part.
transport, that means extension of roads, etc. Lordship.
That is one part of it. But the beginning part is for maintaining supply and service essential to life of the community. or for providing facilities for accommodation, transport, communication. What more is wanted? Transport, communication, maintaining supplies, service essential to the life.
But they are taking it. for-
Imagine a scenario wherein you don't get fuel at the fuel pumps for 7 days. What will happen? What will be the cost?
In Assam, Lordship, they have the refineries, Lordship, they have cold storage, they have storage everywhere.
They will
Lordship.
stop supplying for 10,
And
15
Lordship,
days. What will
Why
happen?
shift the people from the from the agricultural land, Lordship? Enough land is there, Lordship.
That is not your choice, sir. That is not your decision. Where they want land, that is not your decision. The courts can't go behind.
Lordship,
What-
that is true, Lordship, but
That
the people affected should also have been properly heard, Lordship.
They have been heard. That is not your challenge. Your challenge is only based on section 3.
No,
Nothing
Lordship,
beyond that.
That is also point, Lordship. We have raised objections, Lordship, and objections were just summarily rejected, Lordship.
For
And,
that, you have a remedy of appeal. You've taken that remedy. Is there a remedy of appeal in the act?
It is there, and all the persons on affidavit, we have also said that if anybody is not willing, we are not going to take it. Everybody has given NOC, and here,
Not
also,
every-
most of the appellants are not even title holders.
That is why they are in litigation.
Lordship,
And they are not title holders, they do not own any land there. We have given on name, who are the persons not having any land there, any interest there. So this is a frivolous petition on behalf of some vested interest, this petition has been filed. That was our stand taken before a learned single judge also.
Lordship may see how notices were served, Lordship. On that people
It is
notices were
not a
served.
PIL.
We are not, this is not a PIL,
Lordship,
sir.
When we come. before
Whether
this
you
ob-
got a notice or not,
No, Lordship, some people they did, Lordship.
which were the people? Let us know. Where is your pleading? Who didn't get the notice? Was it published in the newspaper?
No, Lordship.
Was there a publication?
Everybody was called to the DC
No,
office.
there was no
All the
public.
persons were personally given the opportunity of hearing.
Okay. Whether there is a right of appeal?
Lordship, we
Mr.
have,
Bhagwati,
Lordship,
is there a right of appeal?
appeal should have been, the order should have been passed by the government, Lordship. But
No.
the deputy commissioner passed the order,
The land acquisition officer, that's the government.
Delegated.
Settled law, delegated power. 3(3), if you could come to the trade court, you could have gone to the appellate authority also. And for that matter, even that restriction of land owner is not necessary. Interested in the land, they could also have filed an appeal.
Lordship, that exactly, Lordship, what I was.
You could have
trying to
filed an
point out,
appeal.
Lordship.
You don't avail of the statutory remedy, then what? Why shouldn't you be non-suited on that only? This larger public interest is involved, sir. Every day's delay costs the public exchequer. 34,000 crores is the cost of the project.
Lordship may see, when agricultural land are taken over, Lordship.
That is happening.
these-
National
these
highway,
people- These people. are
national
all-
highways, where are the national highways built?
Lordship. But this is
Actually, agricultural land has to be
427
acquired.
in a small area, Lordship. In a
Hmm.
small village, 427 bighas are taken away. Lordship.
So what to do? What to do? In Jodhpur, for setting up a solar plant, 500 bighas were taken out from one village. Can't help it. That location, feasibility, viability, the court is not going to go into that.
Lordship.
Hmm.
And notices were also not served on many people, Lordship.
Let us see your pleading,
Lordship.
on whom the notice was not served from your petitioners.
And
And then you will have to answer, how are you interested in the land? That objection is there.
Lordship, we have filed our objections, Lordship.
No objection of the state that they are not landholders.
Lordship, when we had filed the affidavit in reply, Lordship, in the. Lordship, that was not.
Then where is your argument regarding non-service of notice? Read that, please.
Lordship.
It has been further realized that notices were not served on many of the stakeholders. Which one? Which of the petitioners did not get the notice? So the ones who admittedly got the notice, they are out of the picture.
Lordship, in many of the cases, Lordship, I have it, Lordship.
Read from your pleadings, gentlemen.
Lordship, in page 425, Lordship. Of Lordship, WA 275, Lordship.
Read page 79, please.
Lordship.
79, page 79. Your notice, objection. Objection says, we are owner possessors, don't let appeal 280. We had received notices and orders served on us on different dates. Page 79.
Yes,
Yes,
which
please.
one, Lordship? Which petition?
280.
Lordship, that after receiving notices and orders. served
So
on
there are signatures of hundreds and hundreds of people here. Where what exercise should we undertake to find out which of the petitioners were not served the notice now? Or whether can you even raise such an objection argument now after this representation of yours?
In fact, in the affidavit in opposition law, in
Mr.
affidavit. in reply,
Bhagwati, you
Lordship.
can't, if you have taken a stand contrary to your own documents,
Lordship.
why should it be accepted? Read, we are telling you how many signatures are there, count. Which of the petitioners is not a signatory to this document? Tell us.
That I will have to find out.
No,
Lordship.
no, we'll find out, don't worry.
Lordship, in fact, Lordship, in page 425, Lordship, I have given the of 275, WA 275, Lordship.
Sir, we are having 280 in our hand. First, deal with that.
Lordship, there were only 6 or 7 persons.
In 280.
Lordship, in Lordship 275, Lordship, we have lot of petitioners, Lordship.
Okay, very well. 275. Then this representation at page 79, that would be a common representation to the litigants in 275 and 280. The number of persons runs in hundreds.
In the other case, Lordship, we have Lordship 171 petitioners, Lordship.
So that's what we are saying. Count the number. At the signatures, the pages are almost, the leaves are 9 to 10. Starting from 82 to 94. 12 leaves. Everyone would be covered in that. Karuna Kanta Kalita. That is a petitioner.
In fact, we have left after hearing the complaints, Lordship. We have left all the mandirs, masjids and the residential houses.
Okay.
It was not a mechanical exercise. Appropriate exercise was done. Those who have genuine grievance, we left, Lordship.
They had a right of appeal otherwise also. They could have gone in appeal. Yes, please.
Lordship, Lordship may see,
I file. 275.
Lordship, initially objections were raised in, Lordship has seen the signatures of the people, Lordship is pointing out that.
Why should we? There are n number of signatories. So
Lordship,
there, how can we believe your argument that the
in page
people were not
425, I have given the way they had acquired the land, Lordship. In some cases, their fathers have died, Lordship. And the notice was served on the fathers, Lordship, 3-4 sons, Lordship.
So you should have
And-
gone in appeal. What happened? So where is that other item? There is a 309. There is no rate appeal number 275, Mr. Bhagwati. It's 309, 280 and 309. Pankaj Lochan Vaishya.
Lordship, there is Pankaj Losan.
So you were continuously harping on 275. Yes. What is the date of filing of the writ petition, please?
Lordship.
Writ petition, please.
Writ
Date of
petition.
filing of writ petition, yes.
Writ petition or Lordship, writ appeal, Lordship.
Writ petitions,
3528 of 2022, Lordship. Writ
what is the
petition.
date of filing of writ petition? Let us see the date of your affidavit. We'll find out from there. Stop there. If you could approach this court by way of this writ petition, it is presumed that you got the notices. Otherwise, why would you approach this court? If you did not have any notice,
Lordship.
why would you have approached this court?
Because we didn't have the notice, Lordship, therefore they objected, Lordship. You have no notices, you are strangers, Lordship. That is their stand, Lordship. Their stand was,
So, all right, those people who don't have title, they are strangers, obviously.
Lordship, they have,
What
they
is-
are interested, Lordship. The word use is interested,
All
Lordship.
right, so you go and raise your objection that we are interested persons. If they reject your objections, despite the fact that you can show your interest on the land in question, you would have a right of appeal. That is the remedy.
Lordship,
This fact finding exercise can't be done in the writ petition, no? Whether you have interest in the land or not. Whether it can be done now. Just not possible, sir. You chose a wrong train.
Lordship, when the deputy commissioner, when the collector, when the government officials, Lordship, were totally, Lordship, against the people, Lordship.
Mr. Bhagwati, we are not here in a political debate, please.
Lordship.
You tell us why you didn't avail the statutory remedy. Assuming there you raised objections, They rejected it.
Lordship.
they rejected it. There was an appeal. Why didn't you file an appeal? It's an admitted position. You did not approach the
Lordship,
appellate authority.
Lordship.
So there are squatters. Squatters obviously will have to go. They will not be paid anything. Settle law.
When they raise objections in the court, Lordship, I had filed a reply, Lordship. In the reply, it was given how my rights accused, Lordship.
Bhagwati, that issue had to be raised before the appellate authority first,
Lordship.
where the fact finding of inquiry could have been done. Writ is not the jurisdiction to indulge in a fact finding inquiry. You also know very well.
Lordship.
You are a seasoned counsel on constitutional matters. Whether disputed questions of facts can be agitated in a writ
That
petition.
is there, Lordship.
So then there is no way out, sir. Yes, please.
My submission is that only, Lordship. There is no illegality in our whole exercise.
Mhm.
We are giving the full compensation and we have heard all the stakeholders. We have taken their opinion. Those who are having residential house, we have left it from the purview of acquisition. And it is a public interest exercise done on behalf of NRL. NRL is a fully government funded company. Assam government has about 48%. The others are
No, Lordship, 26, Lordship.
26. It has been enhanced.
Mm.
So all these things, Lordship, it is a totally a government. There is no private interest involved in this company.
Mm. Mm.
And it is the outcome of
And,
this Assam Accord of 1985. Central government, state government, and all Assam Students Union and Ganasangram.
Okay.
It's a public property, Lordship.
Mhm. And what about their objection that persons having interest were not heard? What about that?
Everybody, we have gone through everything, Lordship. People are willing to give
We understand.
because the
In
whole area will get development.
But in this kind of acquisition, why don't you publish in the newspaper? What is the reason?
Lordship. In fact, that exercise is not contemplated. What the exercise which we have undertaken out of, as there should not be any difficulty at a later stage. So the deputy commissioner
But
invited
it's
all
like,
the
yeah,
persons.
basically, the purpose,
Yes,
let us see what is the mode of publication.
mode of publication will be newspaper. That will be the section 6 notice will be issued now.
Hmm.
Section 4, section 6, all will be issued. This was a preliminary inquiry which actually is not contemplated for
Ah.
this kind of acquisition. This
Yes,
kind of acquisition is only contemplated under 3(2). Actually, this
What is this?
exercise,
for 3(2), there is no requirement of public notice.
this notice is not required, the exercise which we have undertaken. Because we are not taking this land
So,
to give anybody that erosion affected persons.
No, but even in section 6,
Lordship.
you will have to publish notices.
Yes, that.
So
we are
that
going to-
exercise is still pending.
That is.
So therein they have a right to again to raise
Again,
objections.
again. Because from last year,
Yes.
April, the matter was pending.
Yes. What do you say? The right of raising objection is there in section 7 also.
Lordship, that is there.
Then why don't you wait for that? Why this premature writ petition?
Lordship, Lordship,
They have requisitions the details of the land for the present. Then there are 2 stages given. You could have raised objection there. Raise objection 7.
Lordship,
What is the problem then?
Lordship, what happened, Lordship? Once they forcefully take over the land, Lordship, then
When
all
is-
is lost.
When
Lordship.
does the act contemplate taking a possession?
After Lordship, the
Hmm.
six, Lordship.
Section 4.
Lordship.
Section 6.
Section 6, Lordship, I think,
The
Lordship.
possession is section 4. Power to requisition.
Lordship. Power to take possession of
Section
recreation land, Lordship.
Requisition any land, all right. Served in prescribed manner. What is the prescribed manner?
Where the land-
So acquisition begins when the requisition ends. That is what the law of this court has laid down. Till late, there is no acquisition even, Mr. Bhagwati. Why this?
The manner in which notices were served, Lordship.
Now they will publish. They
Lordship,
have requisition the details. They just,
Lordship,
this is a fact finding inquiry. These are the lands.
Lordship,
Prima facie we require.
Lordship.
They'll issue notice under section 6.
That
Why
is
this
being
premature?
prepared now, the final stage. We're going to issue it.
Yes.
Now, the process they had undertaken, Lordship, they have
Section
used-
3 doesn't say that there has to be a publication in newspaper. Section 6 says, so
Lordship,
they will
Lordship.
publish it.
Lordship, now another thing, Lordship, Form A, Lordship, which they had used
Hmm.
to serve the notices, Lordship.
Hmm.
Form A, Lordship, doesn't give them the power to make any amendment, Lordship.
Amendment to
Lordship
what?
of the rules, Lordship.
Hmm.
That means any modification they cannot do, Lordship.
Modification of what?
Of Form A, the notices they served on the people, Lordship.
Page.
Page, Lordship, 471.
Hmm. Oh, all right. You are referring to landless or displaced persons. That part.
Lordship, they
Ah.
have used that form, Lordship.
Ah.
The additional exercise we have done actually,
Huh?
which was not required. That notice was actually not required.
All right. Rejected.
Deeply obliged, Lordship.
Take liberty to raise objections in section 6, section
Lordship,
7. That is the only. Yeah.
Lordship.
So you want us to make observations right now?
Lordship may make the observation, Lordship.
Lordship, that is already there, Lordship. This will give a wrong, because there is.
You
No,
want,
this is not a bona
Ms.
fide.
Bhagwati, you want us to make observations which may adversely affect your clients. We are asking you.
Lordship, no adverse things should come to my plans.
Then all right, the choice is yours.
Lordship.
You can choose to proceed under section 6, 7 if
Lordship.
you want. What do you want?
Catch-
All right, we'll dispose it of. Cash 22.
What's all right?
Highly obliged.
Okay.
Item number 15.
Hey, hopefully there's a number. in this book.
My lord, 15 and 16
Hmm.
are my lord connected matters.
Hmm.
The government has also filed an additional affidavit.
Hmm.
I have also, because it was only filed on Friday,
Hmm.
I have also filed a reply.
Hmm.
My lord, if my lord can have those on record,
They are all here.
all here, man.
Yes, all affidavits are here.
Have come. Then
Mention was made in the morning.
morning.
Then I had filed it. My lord,
You have not received one.
No, we have filed a reply. We could only serve today, my lord, to my friend.
Rejoinder affidavit.
Lordship,
ours is the rejoinder affidavit.
Yours is rejoinder.
Yes.
So one affidavit is still pending.
Lordship, two are pending, one additional affidavit of the
My lord,
government and
may
my
I
reply.
pray, my lord? We didn't have time to look into, they have served us in the morning, my lord.
So then when, what do you want?
My lord will have it on Thursday, if not others in.
All right, 17th. The affidavits filed by the parties in the last, recently year and before
Today, my lord.
shall be taken on record, shall be brought on record, re-notify on 17th.
Lordship.
There is one matter, Mr. Nair, you were saying that there is. your
My lord
client
had already closed it.
Already closed.
Already closed. And one of the other matter, the second matter,
Hmm.
302,
Hmm.
my instructions were it was not opened. My friend says it is open. So my lord, he can have his instructions if I am there.
My instruction is that in the second appeal, the financial bid isn't open.
Hmm.
So,
And who's?
Everyone.
no,
Oh, sir.
it is available in net, my lord.
I'll also check, ask my
check-
client to check up.
Check and let us know on 17th.
This bid has not been open.
All right, check and let us know on
Much
17th. Very good.
Item number 17.
My lord, 17 to 20, these are connected matters, my lord.
Mhm.
My lord, basically, this is the rate appeal filed by the enforcement directorate, my lord. My lord, we are aggrieved by an order dated 24/7, 27/4/23, my lord. My lord, here is, we are hopping on basically two grounds. First is, my lord, that there was we raised the issue of maintainability of the writ petition in the very first instance. Our contention was that, my lord, there is a statutory provision for alternative remedy. They did not, the writ petitioner did not approach. And the learned single judge failed to appreciate that, my lord. Number one. And number two, my lord, the learned single judge, while passing an order, relied upon an order of Division Bench of Calcutta, Honorable Calcutta High Court. There, I have gone through the order, my lord. There, my lord, we found that, my lord, that order was appreciated by the learned single in half. The second portion of the order, which would have given us a benefit, that was not, my lord, considered by the learned single judge. So, my lord,
This writ petition was basically against the freezing of the accounts
exactly, my lord,
on account of pendency of proceedings under the PMLA.
PLMA Act. And 8(1) application, my lord, I will just, I will not
PMLA.
take much of time, my lord.
PMLA Act. Yes.
My lord, page number 242.
Can we come to page 8 of the impugn order?
Five, 7.
Page 8 of the impugn order.
My lord.
Yes. Para 8. Page 6. Yes.
Right. Accordingly, it's
According to the petitioners.
yes, my lord. According to the petitioner's no freezing order, in connection with above 4+1 bank accounts were annexed in the OA. Accordingly, there was no mention of 4+1 bank accounts being frozen by ED, and importantly, no prayer was made by the ED seeking condition of the freezing. However, the said bank accounts have been frozen by ED and continue to be frozen till date. The ED has, however, produced the freezing orders in their counter affidavit for the first time, but the same was not filed along with the OA,
Yes.
nor was it mentioned included in the OA.
Then come to
Against,
para 17. Para 10. Para 10.
there are 10, my lord. Mr. So and so learned counsel submits that neither any application under section 17(4) of the Act
Hmm.
2002 has been filed by with the executing authority, nor any order has been passed by the executing authority permitting continuation of freezing 4+1 bank accounts
Hmm.
of the petitioner.
Hmm.
He submits that section 17(4) of the Act
Hmm.
categorically provides that any authority seizing any record or freezing any property under 17(1)(a)
Hmm.
shall within a period of 30 days from such seizure,
So if there was no application to the adjudicating of authority for freezing or giving the information of freezing of the accounts or request for the continuation of freezing, how could the freezing have been continued? Read your OA, please. Rather come to para 14.
Para
One more issue. Expired by operation of law. Hmm.
for 14 of the order, my lord.
Hmm.
Para 14,
Yes.
my lord. The learned counsel further submits that the freezing order dated 9/2/22 and 10/2/22 expired by operation of law on 7/8/22. On the expiry of the statutory 180 days from the date of freezing orders.
Hmm.
Yes, my lord.
Yes.
The said provision is contained in section 20 of the Act. Section 23 of the Act of 2002 provides that
Hmm.
on expiry of the period specified in subsection 1, the property shall be returned to the person from whom such property was seized or whose property was ordered to be frozen unless
Hmm.
executing authority permits retention or continuation of the freezing of such property beyond the said period. Therefore, the freezing order would automatically lapse upon expiry of 180 days.
Now, Mr. Dhar, come to para 21 of the order, where the discussion starts.
My lord,
Hmm.
the issue to be decided is as to whether the freezing of the bank account of the petitioners are permissible, although there is no mention about the same in the way.
Hmm.
And subsequently the confirmation order as well. Prior to filing of the writ petition, it was not clear as to whether there was any specific order given to the bank for freezing the bank accounts of the petitioner. But after the filing of the counter affidavit by the ED, it is seen that communication for freezing the bank accounts of the petitioner was made. However, the fact remains that the OA admittedly does not contain the bank account reference and the details of the petitioner as mentioned in paragraph 6 and 7 of this judgment.
Yes.
In order to appreciate the provision enacted in this regard, section 17(4) of the Act may be explained below.
Now come to para 23, please. Where was the reference to these 5 accounts in your OA? And without that prayer having been made, how could the accounts have been frozen or retained in the frozen condition? Tell us.
My lord, I will just refer to the order of the Calcutta High Court, which they have relied upon.
Forget about that, sir. First come to the provision of law and the facts at hand. You don't need any judgment when the facts are clear and the law is clear. Calcutta High Court judgment was on the aspect of limitation.
Limitations.
We come to your fundamental act of freezing, whether it was at all in accordance with law.
My lord, on this, they could have approached the alternate remedy, my lord.
There was no freezing at all. Why should it's a grossly illegal act of yours. Why shouldn't we direct your prosecution, your officer's prosecution for having frozen the account without there being any order, there being any order of the authority empowered under the law to do so? Why is it not a violation of Article 19? You continue to freeze the account of a person for years together without there being any lawful order. Your officer should have been subjected to departmental proceeding for this.
But under 17(4), within 30 days, we have moved before the executing authority.
For what purpose, sir? Which account? Whether these 4-5 accounts are subject matter of your application. Let us see the application then. Whether you have at all disputed this fact that these accounts were not the subject matter of the application. There is no dispute that you have to move the adjudicating authority. Mr. Dar,
Yes, my lord.
you have to do that.
Exactly, my lord.
Whether you at all made a reference of these 5 bank accounts to the authority. And what is the manner in which the authority has directed freezing? Let us see the authority's order. What have you said about these findings in your appeal? That these accounts were never referred to. Come to para 15 of your appeal. Although OA and the confirmation order may not specifically indicate the bank account numbers of the petitioners are covered automatically. Nothing which is referred to is also covered. Everything under the sky. Let us read the language of your OA. Where is your OA? Is there page number?
OA is in, my lord. It starts from page 99, my lord.
Let's read it. And there's a particular freezing order, para 70, page 73. In that there is no reference to these accounts. That is right. 96, 97. But these accounts are never frozen. $99. Yes. The accounts were frozen simply on instruction to the bank. That's all. That's all. What is the quantum of transaction in human here?
During the search operation, my lord, we have
Human here. 09 crores. Yes, Mr. Dar. Where is the order of freezing, sir? Come to page 122, 123, 124. Are these bank accounts mentioned in this order?
No.
They are not.
Lords, they are mentioned in the confirmation order, but these bank accounts are not mentioned in this list of 143 bank accounts. And that was the contention which was appreciated by the learned single judge.
These 143, this list, those
This-
5 accounts are not there.
No, my lords.
Then where is the confirmation order?
My lords, the confirmation order, my lords, the freezing order started at page 94 to 97, which was in relation to the bank accounts, which there was annexed along with the writ petition. The OA mentioned that 122 to 124, as your lordship rightly pointed out, my lords, that mentions the list of 143, which were total bank accounts attached for all the respondents. These 5 bank accounts were not mentioned in that list.
And then in
Thereafter, in the
confirmation, they have.
order, this very same list was identically confirmed.
Okay.
The
But
same list.
even in confirmation, the 5 accounts are not
No, my
there.
lords. No, my lords.
Let us see that list.
Please, my lords. My lords, should I point out, my lords?
Yes, please.
My lords, if, my lords, the confirmation starts at 129, my lords. Confirmation order starts at 129.
Are the instructions given to the bank available on record?
My lords, they had the ones which were for the other accounts that had filed with the writ, that's 94 to 97. The ones for these 5 bank accounts, they had filed along with their counter affidavit.
Counter affidavit.
But then they have not been filed before the writ appeal, it seems. I couldn't find them on the record. Now, my lords, may please be kind enough to come to page 176. This is part of the confirmation order, my lords.
Yes.
And it's the very same list, my lords, which was
Same list which has been.
same list. my lords.
Okay.
Same
So these
143 bank
5 bank accounts are not there.
No, my lords.
That is an admitted position in their,
Admitted position. my lords.
in their reply and writ appeal.
Please, my lords. And my lords, in fact, they sought to highlight a different contention before the learned single judge, which your lordships was had noticed that in para 23, the learned single judge has taken note of their contention and has rejected it outrightly. They tried to contend that on 9th April, all the accounts which were carried out in the search and seize operation, therefore, everything has to be attached. The learned single judge has rightly pointed out, saying that if that was the logic and intent, then there was no reason to specifically mention 143 bank
Mention
accounts and
some.
seek their freezing. Please, my lords.
Yes, Mr. Dar. What do you have to say? Enough scanning of files at the court, Mr. Dar. This will not improve your preparation here.
My lord, my lord.
All right. Anything else to say?
My lord will at this stage issue notice only. my lord.
What for? You heard you enough. There is no concept of issuing notice just for the asking. Notice is here, the parties are here. To whom the notice is to be issued? They are contesting tooth and nail in caveat. All right, that's all. Yes, what do you say?
Lords, in fact, your lordship has not left anything much to be said. My lords, all I'm trying to say is that,
No, but you have to earn your brief.
please, my lords,
Yes.
my lords, my contention at the outset, my lord, is that it is a well-reasoned order where the learned single judge has examined not only the applicable provisions of the law, as well as the law which has been settled by the various decisions of the Honorable High Court in this regard. So
What
there are-
about this limitation aspect seems to be little bit off the mark because that extension by virtue of in the COVID,
Please, my lords.
that would of course come to their aid.
My lords, in fact, that can at best be the only point of contention before your lordship. But however, that, my lords, in my respectful submission, stands settled by the decision of the Honorable Division Bench of the Calcutta High Court, because they are not using their own interpretation. They take their interpretation and they take it on basis of the judgment passed by the Honorable Supreme Court in S. Kasi. And S. Kasi, my lords, dealt with a case where after the limitation, suo motu limitation order was passed, the interpretation was whether default bail and everything would be applicable and whether they can take extension on basis
What
of.
sort of default bail kind of
Please,
provision?
my lords. My lords, so therefore, today here, there is the, if we appreciate the provision says that under 20 subclause 3, the moment the 180 days expires, there is an automatic lapse. And therefore, the property automatically has to come back. So it is akin to personal liberty in that sense. And my lords, in my case,
But by virtue of this order, all freezing, all the assets which have been frozen,
please, my
they
lords,
will get defreezed.
my lords, they ought to have been defreezed, and especially insofar as the bank account. In fact, the other properties which had also been seized during the investigation, that also has to return to the.
But on that aspect, we have our reservations. So,
My lords, that is why I'm not pressing that. I didn't even press that before the learned single judge. It was because the bank
but
account.
then we'll have to stay that part of the order.
No,
Thereby this interpretation has been made.
my lords may kindly appreciate one aspect. My lords may see that today.
To the extent of 5 bank accounts, yes.
No, my lords,
But
may
the remaining account, he is an arguable case.
my lords may kindly understand. Today, there is an argument which is being put forth by the ED, whether the Supreme Court limitation would apply or not. The Supreme Court limitation, my lords, in my respectful submission, that was to grant benefit to the litigants. Litigants who were not able to oppose the court, and that is what the Calcutta High Court has
That
observed.
was equally applicable to the government also.
Milords, I appreciate, but Milords, that would be in a situation where, in my respective.
This is a larger implication. We'll,
Milords, may kindly
we'll
stand.
admit the appeal to that extent only.
Milords,
The
may
5
kindly-
bank accounts will be released. That's
Milords, may
right.
kindly appreciate one thing. Milords.
I'm just placing this to judgments of the Calcutta High Court. What exactly the division bench of Calcutta High Court was held valid?
Milords, may I just permit me to complete one.
That was not even your prayer, gentlemen, to get the others released on the count of the
Milords, it's there,
default.
Milords. In fact, that's the other 2 writ petitions, Milords. Milords, there were total 4 writ petitions which I had filed. These are husband and wife, Milords, and that's why it's 70 to 20. Now, Milords, 2 and 3 were on the aspect that these were 5 bank accounts in total. The writ petitions number 4 and 5 were for the other bank accounts. Now, Milords, over there, the learned single judge was pleased to accept my contention insofar as the 180 days is concerned. And Milords, that was on the aspect that the 180 days, Milords, is to be computed. And the suo motu limitation will not apply. Admittedly, the 180-day period has lapsed. There is no two ways about it. Now, the question is, Milords, here in this factual background, they seek to take condemnation of the entire period from 15th of March 2020 till 28th of February 2022. Now, Milords, the search operation and the freezing order were issued during that period, which is on 9th of February. And what the court took cognizance of, in the single judge, took cognizance of, is the fact that the ED, by that time, the COVID repercussions had finished. And there were no embargo which was on the ED to carry out the exercise. Once they did not have any issues in carrying out the exercise,
That is an arguable point, Mr.
Milords, it's an
Counsel.
argument. I bow down to your lordship that it can be. I can accept notice insofar as the other 2 petitioners.
So, all right, the 2 writ appeals,
Please, Milords.
they have filed it for the purpose of. There are 5 in all or 4?
4, Milords.
4. So 2, what is the prayer? Let us see.
Please, Milords.
311.
311, Milords, the prayer would be in my petition, which your lordships will find at page number 72 of the written.
No, but prayer in their appeal.
In their appeal, Milords, Milords, that is at page number 32 onwards. Of the written. They are just asking seconding aside of the entire order.
So there are 4 appeals in relation to what? There were 4 writ petitions.
Please, Milords.
2 are for release of bank order, bank accounts.
No.
Please, those 5 bank accounts.
Milords, let me clarify. There were
Yes.
more than 5 bank accounts. For 5 bank accounts, Milords, there were 2 petitions, which was writ petition number 2 and writ petition
2.
number 3.
All right.
And for the other bank accounts for which freezing orders were there, Milords, and they were mentioned in the OA, they were writ petition number 4 and writ petition number 5. And
Okay.
as your lordship pointed out, that there are 2 issues at hand here, Milords. One issue is which is
So 4 and 5 were based on challenge to the extended period which they
Please, Milords,
used.
please,
All right.
please.
So on that aspect, we will admit those 2 appeals then.
I stand obliged.
My lord, I will
I
just,
accept notice on behalf of.
I'm just, my lord, taking my lord to para 22 of the Calcutta division bench order, my lord.
Yes.
We start from there, my lord.
Mm.
In view of the above analysis, we find that the learned single judge has not committed any error in reaching to the conclusion that the benefit of extended period of limitations by virtue of the orders passed by the Honorable Supreme Court from time to time in suo motu case number 3 of 2020 will not be available for the extending the validity period of provisional attachment order
Yes.
under section 5(1) of the PMLA. Hence, the learned single judge has rightly set aside the provisional attachment order. Then comes from the next, it starts. The next question raised by the learned counsel for the appellant is as to whether the learned single judge is justified in granting all constitutional benefits of setting aside the provisional attachment.
Para 25 will not affect the adjudication proceedings under section 8 of the PMLA. That will continue.
That will continue, my lord.
that
There
will-
was never an
That
objection.
will continue, my lord. And here, my lord, one thing, my lord, I just, for the sake of argument, my lord, I'm just, para 26, my lord. Learned counsel for the appellant placing reliance upon the judgment of the Honorable Supreme Court in the matter state of Maharashtra for such and such online has also submitted that alternate remedy was
All
available.
right, we are not non-suiting them on ground of
My
alternate
lord.
remedy.
And then,
And
Whether this judgment has gone in appeal, Calcutta High Court.
no, not to my knowledge.
Calcutta High Court, yes, my lord, Calcutta High Court,
I checked. I stand corrected.
my lord, I'm placing this, my lord.
Let's see.
They have gone, my lord,
What has happened?
dismissed.
Okay, so that judgment is affirmed.
Please.
No, my lord, the second part, they have gone for the second part, my lord.
The first part is.
What second part? What do you mean second part?
Post, my lord, we did not challenge, my
The
lord.
parties have gone.
Parties have gone, my lord, not
All
us.
right. So
No,
the
there was-
retention of section 5 and the section 8, to that extent, the
So,
judgment has
Lords,
been.
I am not challenging that aspect. In fact, I'm not even saying that the due procedure should not follow. In fact, my entire contention is that due
Then
procedure not be
we
followed.
can accept their appeals, writ petitions number 4 and 5 right now. Let the proceedings continue.
Yes,
What
the
is it?
proceedings are anyways continuing, my lords. In fact, my lords will appreciate that the OA does not even mention any abovement per me. I'm not mentioned in the EIR,
All right.
ECIR or FIR.
Just hold on. Writ appeals, give the other files also.
My lords,
Where is your writ petition, gentlemen? Let us see.
my lords, that will be item number 18 and 19 before your lordship.
No, in this first file, writ petition number 2.
Please, my lords.
Where is your writ petition?
Please, my lords. My lords, this was in relation to those 5 bank accounts as your lordships are tightly
Yes.
flagged.
Where is your prayer precisely?
Please, my lords. My lords, may please have page 72.
72.
Please, my lords.
No, writ petition, they have filed it in the appeal.
Please, my lords.
That is at page number 31. What is the prayer?
My lords, I was given a copy. Prayer was at 72.
All right, 72.
Please,
Just hold on.
My lords, should I read it?
Correct. Your prayer.
Yeah, my prayer.
Yeah, it's in second.
Right. 4 bank accounts, yes.
Please, my lords.
Mrs. Hari Enterprises.
Correct.
Hmm.
That was the proprietorship concern of the petition, the respondent number 1,
Hmm.
Ramthari. And in the item number 20 before your lordship, so that's writ petition number 3. And where there was single bank account,
Single bank account.
and that was Mr. Laranwar, which was the respondent number 1.
Okay. So, these 2 appeals will dismiss. The other 2 will admit.
My lord will observe that the second part, my lord, that
We will simply say that we are not entertaining your appeal on the ground that there was no reference to these bank accounts in your OA. Only on that ground. To that extent only we are making the observation. So writ appeals numbers 311 and 312.
314 would be, my lords. As per my understanding.
314, 312, what is the prayer?
312, my lords, that is for
Which is the
other
writ
bank
petition?
accounts. My lords, that's writ petition number 4.
5. 312 is writ petition number?
4, my lords.
4.
that's one. Yeah, please.
Yes. So there is a common order in 4 and 5.
My lords, what had happened was because the issues were same and the facts were same.
So 4 and 5, there is a common order, and 2 and 3, there is a common.
Indeed, my lords.
So 2 appeals arising out of 4 and 5, they are admitted and there will be a stay on that part of the order.
My lords, I am opposing the stay, my lords. My lords, may give me 2 minutes to be able to give the reason, my lords. I'll
Once
tell you.
we are admitting it, Mr. Counsel.
No, my lords, I'll tell you the reason, my lords, as to the stay. My lords, I'm opposing only the stay, not the issuance of the
What is the
notice.
direction given? Let us see.
Please, my lords.
What is the consequential direction of this?
Because the consequential direction has only been given so far as these bank accounts are concerned. That these bank accounts should be done. And in fact, there is no direction so far as anything about.
No, that consequence,
My lords, in fact, that we.
impugn freezing order and the confirmation order,
So far as
insofar as the bank accounts.
Please.
So there are, that will have an implication on, all bank accounts have
all
been.
bank
My
accounts, my
lords,
lord.
in fact, my lords, may I kindly appreciate, my lords, that there were, apart from the bank accounts frozen, there were other properties as well as records which they have seized.
Hmm.
I am not pressing for that, my lords. Though my petition was for that also, I am not pressing and that has not been granted because.
All bank accounts which were referred to in their OA also, they have been defreezed,
No,
which.
only
which-
for the petitioners, my lords.
Yes, but they were referred to in the
They
OA.
were
We are presently, we are dismissing their appeal only on that ground, that those bank accounts which are not referred to in the OA, the
My
single
lords,
judge
my
was
lords, may kindly
justified.
permit me to file a reply to the stay application because it's not even made out. A case for stay has not even been made out or pleaded in. the
All right, we will issue notice to the respondents. Mr. So and so appears on behalf of the respondents number so and so. Heard on prayer for interim, giving liberty to the respondents to seek vacation of ad interim stay order, comma, in the interim, comma, until next date of hearing, comma. It is hereby directed that direction given by the single judge to defreeze the bank accounts of the writ petitioners referred to in the impugned order shall remain state. Okay.
My lords, in fact, the only thing is, my lords, that today I am left without because my accounts are frozen. I am not able to carry on my business also, my lords, and that's a
Yes,
lot
all
of
right,
business.
we'll
I
hear
paying
you
tax
then.
on that.
We'll hear you.
Few accounts have been defreezed also.
Maybe. maybe, doesn't matter.
In fact, okay. Like,
Re-notify, counsel for the respondent is given liberty to file affidavit in opposition in these two writ appeals.
obliged.
निकाल देना अलग से 4 and 5 वाला writ appeal अलग कर दीजिए 2 and 3 writ petition
4 and 5 is 18 and 19, Lords.
18 and 19 are 4 and 5, so these two will be issue notice,
Please note,
stay, and 17 and 20 dismissed.
please note.
Okay.
Would your lordships be kind enough to fix a date, my lords, because I traveled from Delhi for this, my lords? Only if your lordships find it
On
convenient.
2nd October, 2nd November.
2nd November, my lords, highly obliged.
Deeply obliged, my lord.
You are putting in appearance for all respondents.
My lords, only respondent number 1, my lords, and all that.
Respondent number 1, notice steps of service on the remaining respondents be taken in 3 days, whereafter process be issued.
Obliged, my lords.
My lord.
Item number 21.
What is this PI?
Regarding whether the police stations are having CCTVs or not,
No.
under the Honorable Supreme Court judgment.
Right.
So
Now there's further direction. Recently, 2 or 3 days back, one more direction has come. What has happened? That we had given direction for Assam also.
Assam also, Lordship. So I have the figures.
Hmm.
My figure is dated 16th of June.
16 June, you have already given out the figure.
Yes.
Latest report now. We are
On 16th, 5 were remaining out of 332.
okay.
So I have to get
But
the up to date.
Is there a central control room for all of
Yes,
them?
We have.
They are interconnected.
Yes, we have. From Ulubari, that the headquarters, police DGP.
Can you give us this procedure on an affidavit?
Lordship.
This we can work, Ms. Saikia. If you have that connectivity of all police stations,
Lordship.
then why don't you start working on that e-prison software so far as the custody period of the custody certificates of the accused are concerned?
Lordship.
You can use this facility for that purpose.
Lord.
Because supposing there's an accused caught in Golpada and there are cases against him in Dibrugarh, so you'll immediately get information.
Lordship.
That connectivity, if you can establish, that is the very purpose of the e-prisons software and the custody certificate. That there is an information data regarding every accused who is brought into the system. The entire system has the information about it. So that's an important aspect. Which
Very important. There are a lot of cases where it subsequently arrested, soon
you go
arrested.
find out the man commits an offense in a different district.
Yes.
He absconds. He is apprehended in another district. He gets bail. You don't get a whiff of it
Lordship.
in the place where he is absconding. So that's how the things can be made very transparent, smooth and foolproof.
Lordship.
So we'll make few observations in today's
Yes,
order.
Lord.
And we'll re-notify it maybe in once before September.
Yes, Lord.
So the order will pass it on to you.
Lordship.
You may work on that.
There is another issue, my lord, for Lordship wanted to know from state of Arunachal Pradesh, whether the notices in that criminal petition were served upon the.
Yes, Lordship, with regard to that notices, Lordship, it's already been served upon, but they haven't yet appeared before the Itanagar bench, Lordship. This is the last order, Lordship.
Let's see.
16/6/23 order, Lordship,
Yes,
last
yes.
paragraph, your Lordship.
Yes.
Because
Mr. Chandran, Senior Additional Government Advocate, Arunachal Pradesh, has informed the court that notices of criminal petition number 118/22 have been served, have been taken through Dasti mode, but the fact regarding service thereof is not reflected from this order.
No, Lordship, it has been served upon the respondents, Lordship.
It has been served. The order says
Lordship,
from the office note, it reveals that service of notice upon the already taken. Informs the court that service of notices of so and so have been effected on the respondents but they have not put up appearance in the court. The learned single judge, hearing the aforesaid petition, is requested to expedite the disposal thereof. My lord, copy of this order shall be transmitted to the Registrar Itanagar bench forthwith. Regarding the CCTVs, we'll pass it along.
I understand. Yes, ma'am.
What has been done in Arunachal?
Lordship, letter says that the 3-member committee has been formed, Lordship, to look into the logistics.
Any status report, peculiar
Lordship.
report?
Lordship wanted to know whether it was made centralized or not.
That the
Centralized-
letter, there is no connectivity, that's the
Lordship.
problem.
Yes.
We are unable to formulate a centralized control center for the CCTV feeds. It will be monitored by so and so, yes. All right, we'll incorporate this. And we'll make observations regarding that custody certificate aspect and the sharing of information of the accused in all police stations.
Yes, that will be very useful, my lord.
Yes.
The order is at 16, second paragraph, my statement is there. Inform that CCTV feeds are being monitored at the centralized.
Yeah,
Yes,
that we
Yes, sir. That is there.
re-notify on 30th August.
Highly obliged.
Much obliged, Lordship.
Deeply ordered.
Item number 22.
This is the appeal by the revenue. Proceed the question with regard to the incoming materials. Supreme Court has said if there is no incoming materials, there cannot be any resistance. But here, Lordship, I file a IA urging before your Lordship that the material seized mark as page 61 to 69,
Yes.
whether that can be considered as incoming materials. or not.
That is in the IA.
Yes, sir.
Hmm.
And otherwise, Lordship, the matter is covered by the Supreme Court judgment.
IA simply says
Regarding Lordship,
page number 61 to 69 of what?
Lordship, IA Lordship. Page,
IA is running in 5 pages only.
yes, Lordship.
So where are the pages number 61 and 69? For that, the seized materials, that is page number 61 to 69 of seized material bearing identification SST01.
That was seized during the search and seizure, Lordship. Now our contention is that these materials are incoming materials. On that basis,
What is that material? And how it has been dealt with it by the tribunal?
Lordship, appellate authority says that these are not incoming materials.
So then that is a question of fact.
Lordship, but when the Supreme Court says that there cannot be reassessment or assessment on the basis of incoming materials, when these are the not incoming materials. But in my humble submission, Lordship,
If the appellate authority has said that this material is not incriminating, whether we can substitute our wisdom for that. Let us see the finding.
Lordship, assessment order first, Lordship. Page 13, page 12. Lordship.
Why don't you come to the appellate authority's order? That is para 4.
Lordship, I can- Paragraph 52 is
Despite specific requests, the AO never provided the details of the asset which had purportedly escaped assessment of the SSC for the AI 120112012.
Para 51 also.
Para 51.
My lord.
page 196. In view of the fact as discussed above, the judicial precedent, Chopra, we thus call that the assertion of AO in the satisfaction note of page 61 to 69.
What was precisely that material?
Total income of which is.
What precisely is that material, Mr. KL?
Lordship,
What is the material at page number 61 to 69?
Lordship, I'm coming back.
Dr. Saraf, can you point out that material?
There were the printouts of the ledger account, which were regularly books of account, they were maintained. You'll also find a page 174. At the bottom, 4 lines.
Yes.
Hence, the most important aspect is that the assets must have been found undisclosed, unaccounted in the regular books of account maintained by the SSC and discovered during the course of search, which otherwise would not have been in the light of the day for the search resulting in the assessment. It is kept in mind that the term investment in the shares and seizure has been considered with the term asset. The term investment in the shares, we will skip over the last 5 lines, 7 lines. Essence, it does not suggest to include the documents received by the SSC, proceeds received by the SSC on sale of so-and-so, to say if the credits in the regular books of account, like sale proceeds, etc., is found to be unexplained, then it may cause of discovery of undisclosed income, cash credit, but it does not suggest discovery of undisclosed asset by the revenue so as to bring. Whatever was there in the books of account, that was considered, they say that this is undisclosed. Now, there was no addition made on the basis of the undisclosed materials and incremental material. There is no addition.
2011-12 assessment, there was no addition.
No, there is no addition. Now, if the incremental material, there is no addition, then how can we say that there's some incremental material was there? And the tribunal has said, and that's incremental material which they are saying, that was assessment was reopened, and that materials were considered and found to be that we are explained.
That has already been reopened.
Earlier, it was reopened.
Where do you find that?
Fine.
Come to para 25.
Page 159.
159. That is what we were referring to, para 4.
And 158, 4 lines, last 2 lines, 158. In the course of the assessment, assessing of required SSC to explain why the proceeds of so-and-so received upon the sale of investment holdings should not be added as plain credit under section 68 of the Act. In response to the SSC furnished explanation as to why the addition was unwarranted and entirely contended that the SSC had shown the sale transaction in the regular books of account, and by no state of relation, sale transaction can be said to have this and receipt from can be said to be and from undisclosed receipt, which is escaped assessment. The assessing officer, however, did not agree with the statement put forward. He alleged that the SSC had bought back his undisclosed income in the guise of the sale of investment, and there so and so. Now, you'll also find that these were the assessments which is said that it was found in the regular books of account. If something was in the regular books of account, the question of saying that turning it to be incrementing material found in the time asset, incrementing asset, above 50 lakhs, unless and until some incrementing material above 50 lakhs are found, no addition, no notice can be issued. Now, this was in the regular books of account. And in the regular books of account, whatever is there, how that can be said to be incrementing materials?
Then come to Mr. Kale, come to page para 25, page 176.
Paragraph 25. Keeping in the mind the above, we note that the SSC specifically objected to AO's action of reopening of unabated assessment year 2011-12 under section 153C of the Act, and has requested the AO to give details of the purported assets and disclose unaccounted assets unassigned during the search for the SSC for the year 2011-12. The SSC, the AO, however, did not point out that when provide the details of the undisclosed unaccounted assets of the SSC, which were in his position.
So there was no satisfaction that there was any undisclosed income. Okay, very well. Dismissed.
The new question which my learned friend proposed,
in the IA, that may also be taken into consideration, because. And your lordship has already given a judgment, Milord. I may give a copy. Copy
Yes.
in respect of the received by the Naga, Milord, the income. Interest.
And
In fact, I prepare a compilation, I give this one, here it is there, Milord.
hmm,
I prepare a compilation also for a convenience of your lordship, Milord.
there's a compilation of the. Yes.
I'm highly obliged, Milord.
Yes. There's para 4, para 23, 25, 16. All pending are there. Yes.
Item number 23 and 24.
Please, your lordship, I pray for some more time to file our affidavit, my lord.
And counsel for the state. Pray for and granted further opportunity of 4 weeks to file affidavit. Position list up to 4 weeks.
So there is one more connected cases, lordship, that may also be tagged.
File of so and so shall
Application
also
number
be tagged and
4265.
listed together with these 2 writ petitions.
Obliged, lordship.
Top of the list matters. Item number 1.
Hmm.
Lordship, contrary findings of all the courts below,
Hmm.
3 courts below.
Hmm.
The original adjudicating authority has dropped the proceedings against me by
Okay.
dropping both the demands.
Hmm.
The appellate authority has again raised both the demands against me.
Hmm.
And the Central Excise Service Tax and Appellate Tribunal at Calcutta, it has dropped one demand and it has upheld one.
Retained one demand. Yes.
Lordship. Now, Lordship will please peruse order dated 28/1/2019 in this Central Excise Appeal.
28.
28 January 2019. The substantial question of law that was formulated by this court, Lordship.
Yes.
Second page, it
Hmm.
states Roman 1. When the plant and machinery purchased by an SSE in an financial year
Hmm.
without appropriating them or installing them for the use in manufacture of finished goods
Hmm.
by an eligible unit, whether the SSE is entitled to avail SENVET credit in respect thereof, treating the same as capital goods under Rule 4 of SENVET credit rules. Lordship, the dispute in this petition
Hmm.
is that I had purchased plant and machinery. I was already an existing unit. I was availing exemption,
Hmm.
area-based exemption.
Hmm.
I purchased another plant and machinery
Hmm.
since it was available at very cheap prices. Without deciding whether I will sell it off or whether I will install it as capital goods in my factory, I took the delivery, I kept it in my factory.
Hmm.
There is no dispute to the effect that I purchased it in 2007-8. And subsequently, when I decided to use it in my factory itself, I claimed the SENVET credit, which I had paid as taxes while purchase of the said plant and machinery.
Hmm.
It is the department's case that the exemption notification states that every credit which is available at the end of the month
That has to be claimed.
has to be first availed,
Hmm.
and then the taxes have to be paid, and then the refund has to be taken by the department. So they have tried to prepare a case that since 2007-8 was the year of purchase, and 2010-11 was the year of claiming of SENVET credit,
Hmm.
it was not claimed in the first year when it was received.
Hmm.
And our case, Lordship, is since the definition of capital goods itself suggests that until and unless the goods are used in the process of manufacture, those could not have assumed the
Character of.
character of capital goods. And so SENVET credit could only be taken when I use it in my factory.
Hmm.
This is squarely the case, Lordship,
Right.
before you.
Hmm.
Now, Lordship will peruse the impugned order. It is at page 39, Lordship.
Yes, please.
Lordship will peruse paragraph 2. Allegedly, the appellant procured capital goods from Inox Air Products, but retained the same in their factory without installation to obtain a higher refund under notification number so and so. It was held that deferment of availment of Senvet credit till utilization enabled payment of duties of central excise by cash, which was then claimed as refund that was limited under the said notification to the amount of duty paid without recourse to Senvet credit. Learned Counsel for Appellant contends that the definition of capital goods in Rule 2A of Senvet Credit Rules 2004 mandates the deployment and usage of such goods within the factory. It is further contention that Senvet credit can be availed within a prescribed period after the capital goods are installed, and that the facts and circumstances were known to the jurisdictional authorities. Reliance was placed on the decision of, this is wrongly quoted Supreme Court, it is MP High Court Lordship. Learned authorized representative places reliance on the decision of the tribunal in Sun Pharmaceuticals. Having heard the rival submissions, we take note that the issue relates at the point at which the Senvet credit should have been availed by the appellant. It is not in dispute that the goods have been procured well in advance of installation and that Senvet credit was taken subsequent to assembling and against the same invoice on which the goods were procured. From this, it is clear that capital goods were delivered by the suppliers and received by them in their factory during 2007-8. The usage, while usage within the factory may well be an expression employed and adduced in the definition argued by Learned Counsel, it is Rule 3 of the Senvet Credit Rules that authorizes availment of credit, and that too specifically upon receipt in the factory. These two lines, Lordship, has to be interpreted.
Yes.
In
May
the,
we annex the rules, please?
yes, Lordship. These rules have been notified under section deriving powers under section 37 of the Central Excise Act 1944, Lordship. Lordship will peruse Rule 2A. It defines capital goods.
Yes.
Capital goods means the following goods, namely, there are several categories. There is no dispute that it does not belong to the said category, Lordship. Then it uses the word used in the factory of the manufacturer of the final products, but does not include any equipment or appliance used in an office. So the core emphasis is on the word used, which has been.
Used means that it can be employed only for the purposes specified below. Doesn't mean that it should have been consumed.
No, Lordship, in states where the exemption is not enforced, they are taking a plea that since it was not used, you will not get credit. They are taking a plea that since you have purchased it and you have sold it off, you will not get credit. But in states where the area-based exemption is applicable, they are taking another plea. That use has no relevance at all. So Lordship will now peruse Rule 4, for which the dispute has occurred. Rule 4 will be. Lordship, it is at page 8 of 22. The bottom side.
Yes.
Conditions for allowing Senvet credit.
So
The next
immediately
page-
on receipt of the inputs in the factory.
That is inputs, Lordship. We are talking about capital goods. Page 9, first paragraph, Lordship. 2A. The Senvet credit in respect of capital goods received in a factory or in the premises of the provider of output service at any point of time in a given
financial year.
financial year
So
shall
you
be
want
taken.
to defer the receipt. You by what your prayer is, you defer the receipt because I did not put it to use.
I did not put it into use. Yes, Lordship.
Yes.
So that is clearly the case. Now, Lordship, whether the expression use which has been defined, the capital goods has been defined, whether it is only an expression or whether it has any significance, the case will boil down to that.
Yes.
For that purpose, Lordship, I have some Supreme Court judgments which might help us.
There is a difference. In when you see 2A,
Lordship.
That very clearly qualifies received in a factory at any point of time in a given financial year.
Yes, Lordship.
So
But
these are the-
capital goods.
Yes.
There, I have quoted a Supreme Court judgment, Lordship, in which the manufacturer had purchased the plant without installing, he had sold it off. And for that case, Supreme Court has held that he will not be entitled to Senway credit. The similar might have been my case unless and until I use it. How can I claim credit, Lordship? So for that, Lordship will peruse first the Madras Cements case, 2010. Paragraph 11 and 12 will be relevant, Lordship.
Yes.
As indicated initially, the short point involved in these appeals relates to the eligibility of the SSE for moderate credit on certain capital goods, which were said to have been used as components, spares, and accessories in the manufacturing process of the appellant for the period in question. In order to avail moderate/Senway credit, an SSE has to satisfy the assessing authorities that the capital goods in the form of components, spares, and accessories had been utilized during the process of manufacture of the finished product. This is one judgment, Lordship. Then another, which relies on this judgment, will be KCP Limited 2013, paragraph 23 and 24, which quotes the Madras Cement judgment, will be relevant, Lordship. In our opinion, the above stated reason is quite sufficient for denying any moderate credit to the appellant because it was not used. The paragraph 24, Lordship, it is also not in dispute that the appellant had purchased some machinery from others and such machinery had not even been unpacked by it, and in the exact condition it had been transported along with the machinery manufactured by it to Vietnam. Thus, the appellant did not use the purchased machinery in its premises or in its factory, and therefore necessary condition incorporated in the rules for availing credit of the moderate had not been complied with. To avail the moderate credit, the input on which excise duty is paid must be used in the manufacture of the final product in the factory of the SSE. The machinery purchased by the appellant had not even been tested or was not even unwrapped in the factory of the appellant. In case of such an admitted fact, it cannot be said that the machinery so purchased from others was used by the appellant in the manufacture of the sugar plant. So this was a similar case, Lordship. If I take it, they make another case. If I don't take it and defer it, they make another case. So since the use word has specifically been used by the legislature in the definition, proper emphasis has to be provided to the said word use, Lordship. And accordingly, I have not faulted when I have deferred the said word credit. So the demand of recovery, which has been stated to be erroneous, might be dropped against me by deciding the substantial question in my favor, Lordship.
Yes, Mr. Chair.
What's the first appellate court?
What do you say about these two judgments? Brought, not used.
What's if I have not concluded anything?
Can this be the argument, gentlemen? You are supposed to be aware of law.
No, Lordship,
All right, read the judgments. We'll hear it on 22nd then. 24th.
Lordship.
Give the copies of the judgment. You can share the citations in advance, Mr. Saraf. List on 24th, as per advice, Mr. K.
Obliged, Lordship.
Item number 2.
ये निकालो 2013 supplementary SCC 513. Yes.
May please the Lordship.
Yes, please.
Lordship, in this case, the appellants are the present appellants are the legal representatives of the original appellant, your Lordship. And the issue involved in this case at present is that to give retrospective effect of promotion and the monetary benefits, your Lordship.
Yes. 2013 supplementary SCC 513. Yes. Date of creation of vacancy should be treated to be the date on which the promotion becomes effective. That is your argument.
Yes, your Lordship, on the date of DPC, your Lordship.
DPC, all right.
DPC,
Assuming date
or-
of DPC, yes.
Or from the date of.
Does their employee, does any employee in a public service have a right to be promoted or right to be considered for promotion?
He was already considered, your Lordship. He was selected and subsequently he was
Yeah,
given
so the
permission.
learned single
That he
judge
was
holds
appreciating.
neither the fault of the employer nor the fault of the state. The matters were pending in this court litigation. There was a stay. What can the employer do? It's not the fault of the employer. So why do we issue the writ for?
Lordship, not for the fault of this appellant, your lordship, original
It
appellant.
was not the fault of the
Because
employer
the
as well.
other-
It was not the fault of the employer as well, madam. Read the judgment which has been relied upon. 2008, volume 14 SCC, page 29. Nirmal Sinha, Nirmal Chandra Sinha. It has been then followed also. Hmm. The title is Ashok Kumar Srivastava. Yes, please.
In this case, your lordship, Nirmal Sinha, he claimed promotion from the date of vacancy.
Hmm.
And in our case, your lordship, from the date of DPC when he was selected, your
Yeah,
lordship.
that is all
Or from
right.
the
The
date
state,
of
what is the
office
fault
sitting.
of, why should we penalize the state? It is
Doesn't-
it is the litigation because of which the matter was struck. So
For
what
the
can be done?
other, not for his,
Neither
the
his fault
other-
nor the fault of the state.
and also from the administrative lordship, in one time, there was no stay, your lordship. That during,
Then
2 years.
you should have pressed before the court.
Yes, your lordship.
Yes, so the court did
We have
not.
filed representation also, your lordship. So no fault of his, your lordship.
Give us any law on the point.
Lordship, 1 minute.
Sure, take your time.
Lordship, 2007, 6 SCC.
What is the ratio of the judgment, madam?
2007, 6 SCC 524, your lordship.
Hmm.
In this case also, well, that administration wrongly denied his promotion due, your lordship.
So administration never denied in this case.
In this case,
at
they never
hand,
denied, but administrative lapses here because
there was no
during-
lapse on part of the administration.
lordship,
It was
he
a
was-
litigation in which the matter got stuck. That is the reason the single judge has denied you the relief. Read the ratio of
And
this
he was-
judgment.
he was working as that post also, promotional post, your lordship.
Hmm. Who was
From
working?
2000,
He was working on the,
as GM, your lordship, in charge he was.
so he was already drawing that salary.
No lordship,
Why not?
he was not given. That's why, your lordship, only from the actual promotion, your lordship. That was in
Where is your
99.
pleading? Where is your pleading that he was working as a GM from that day? Let us see that pleading then.
He was working as his GM in charge later on.
Later, from
That
what
is
date?
2002, your lordship. So that's it.
Ms. Kalita, if he was working as a GM in charge, then what is the problem in granting him?
That DPC happened in, DPC happened
2000.
2001.
in 2001.
Yes, and he
Then
was,
like-
he was assigned the, as per their pleading, he started working, officiating as the GM.
Officiating as,
Officiating as GM later on, lordship.
In which was date?
37, 2002.
37, 2002.
No, no, not,
10,
not this.
there are
Supplementary SCC.
25.
2000 बताया ना 2013 supplementary SCC 513. You don't have the book. Book नहीं है. Bring my mobile. Yes.
Lordship, para 10, your lordship, para 9, page 25. The notification is in page 8, your lordship.
Page.
Page, para 8, page 23. That is the notification was issued.
Of your writ petition.
Yes,
For
your
appeal.
lordship. The appeal memo is there, your lordship.
Appeal memo para 8.
Para
yes.
8, your lordship. That after publication of aforesaid.
That is
and
assistant director.
Assistant Director Cottage Industry, then initially with effect from the next page, your lordship. 1, 2, 3, 4, 5, 6 line, your lordship. Thereafter, on 37/2002, by notification under this, the petitioner has been transferred and posted as functional manager in charge, general manager.
Mr. Kalita, from the date on which he was discharging his functions as general manager, you already recommended in 2000. You posted him as in charge general manager. From that day, why he will not?
That lordship, like that's in charge is like not in substantive promotion. It was under 4D.
Understand? That we understand. But you have promoted him. You had promoted him from before that. Why shouldn't it be given effect from the date he started discharging those duties?
He charged, your lordship, yes, lordship, he started discharging his duties as GM in charge from obviously lordship. That's
From
not
that day, he is discharging those functions. From that day, at least the financial benefits can be. Even on the principle of no pay for no work.
That is.
He
But
is
he
working
was
on that.
working, yes,
From
your
that
lordship.
day, he can very well be granted. So there will be a period of 3 years.
3 years.
3 years.
For which, and the cascading effect also.
Cascading effect will be there. Okay.
Why not that? That can be considered, we feel.
Let the department consider lordship,
Why? What is the department going to do now?
because
What the department will do now? Is a dead matter now.
the only thing
The
is that
employee is no
the
more.
Only thing is that
The employee is no more. Now it's only a question of financial benefits to the family members. Let that, at least he was given this,
actually that is correct, lordship.
because of pending litigation, he was denied of his
Yes.
genuine
Factually,
entitlement, basically.
Actually, he was recommended in 2001 only.
That's right.
And like he started working. from
Working in 2002, from 2002, on the date he started functioning, we can give that benefit.
Also.
Okay. We'll consider.
Much obliged. lordship.
Obligers.
Or reserve. Or reserve. छोड़ दीजिए, कोई बात नहीं, हम निकाल लेंगे, प्रिंट कर लेंगे.
Item number 3.
Please, actually, in this matter, I'm led by Mr. Kane Chaudhary, London Senior Counsel. He's on legs. Can it be called after some time?
After some time, after 3 minutes.
5 minutes, my lord, not more than that.
All right, password. Age relaxation contrary to rules.
Item number 5.
Lordship, in this case today, I am having some problem because there is a MBBS matter going on, Lordship. That will consume my whole day.
Senior advocate Mr. Saikia submits that he is not prepared with the matter today and plays for a short accommodation. Re-notify on
Maybe in the last week of this month, Lordship.
30th August.
Highly obliged.
What precisely is the controversy, Mr. Das? What is the controversy?
Controversy regarding about the absorption. An employee who has come on deputation,
Ah, right.
the government has absorbed him,
Right.
whether the rules, whether there is a power or not.
Power
That's
of,
all.
In this
yes.
case, Lordship, the record may also be required because the learned single just says that there was no reason cited. If it is in the record, then that will,
We will see it, Milo. Your lordship will look into it. If required, then your lordship.
Get the record, by the way,
Right.
Mr. Das.
Record.
Get the record. On that, on the next date, comma, the original record shall be kept available for perusal of the court.
Because it is a part of, in the appeal itself, from page 74 to 79. The reasons recorded, but
Yes.
learned single will get respect says that no reasons have been recorded. We will produce it, Milo.
highly obliged.
Deeply obliged.
Supplementary list, item 25 and 26.
Yes. I didn't get the list, but it's there.
My lord, in the income tax matters, your lordship permit me, I'll give the relevant paragraphs of the.
Please.
My lordship, will take up WPC 25, no? Item 25, you know.
Yes.
Well, first of all, the validity of the rule which is in the challenge. In my feeling, the now it has become academic,
Okay.
because the division bench in the pendency of the petition directed the petitioner to go in appeal, and the appellate order has already been passed. So that will become academic without the
Okay.
unless it's excise when we proper.
Right.
The issue now in the sort which I'll come to before also, there was a dispute that whether there was a unauthorized use of electricity, whether there was a theft of electricity, that was, I will show to you also.
Single bench matter.
Whatever.
This was
Goes to the single judge.
It should go to single because challenge was to the rule. That's why it is before the event.
But I think now going to single
We'll
bench,
be
it
losing
can be
on
decided here, sir, because we want to, that, the question is that the appeal and let the division bench decide it, for.
But if the validity part is not being agitated, then it has to go to the single judge. Dr. Saraf, senior advocate Dr. Saraf, representing the appellant, petitioner submits that in view of the subsequent developments, the challenge late in this writ petition to the rule 3 of the appellate authority rules 2004 and does not survive. He thus submits that the remaining prayers made in this writ petition are required to be considered by the learned single judge in view of the submission noted above, and as the challenge to the validity of the rules has been does not survive any longer, let the petitions be placed before the single bench concerned for consideration.
Deeply obliged.
ये return कर देना.
I thought that on the short matter, it could be disposed of by the.
Let the single bench have
My lord.
to exercise jurisdiction in this.
Pass over matter 3.
You want this to be attached in the file?
I thought that for the convenience of lordship, the income tax matters.
Acha, it is in that. We thought it is in this one.
No,
Okay.
income tax matters.
Okay, okay. Please pass it on. ये उसमें लगा दीजिए. Yes.
I'll start with the facts.
There is hardly anything between the start and the finish. Starting and the finishing line are very close. Age relaxation, 44 years. What is
44
the
years.
power to relax and how it has been excised?
Yes, madam.
That is the issue. The rule lays down specific grounds on which the power is to be excised. Let us see the order of relaxation. And whether there was any relaxation as such. The order is reproduced at page 4 of the judgment. Read that.
It starts with, well, sir, I'm enclosing here with a photostat copy of the application dated 11/6/2009, along with its enclosures, which is self-explanatory. I'm directed to say that the government in the education higher department is pleased to refer to the condonation of overage up to 45 years in respect of Ashutosh Kundu for applying for the post as in terms of the government existing rules.
So where is the relaxation?
Although, my lord, there
Where is the order of relaxation?
no specific order of relaxation.
Where is the opinion of the APSC, which is
But,
mandatory?
but the, my lord, the fact remains,
He was allowed.
he was allowed.
So
and
whether the action of allowing the appellant to apply for the post, to work on it for so many years, would indemnify the illegality on the face of the record,
my lords,
at the root of the matter.
my humble submission, my lords, this court has to consider, my lords, while joining the new post as lecturer, he had resigned from his earlier post. my lords.
We are not bothered about it.
He had
It's a grossly illegal act, Mr. Counsel.
He had
Grossly illegal.
applied through proper channel, my lords.
Doesn't matter. There was no order. He shouldn't have taken the risk.
Yes.
Show us the order of relaxation, please.
That,
Can there be a deemed relaxation of age? That is what you are asking the court to do.
that's what ground has been taken, my lord.
Give us any judgment that there can be a deemed relaxation of age.
I would, subject to what my learned senior argues, my lord, I would rather argue on the equity point of view, my
There
lord.
is no equity in this. This is an exceptional exercise wherein the other candidates, they are given a go by relaxing a age for a particular person where there is no relaxation as such and the rules don't talk of such relaxation. Relaxation has to be for specific grounds.
In fact, my lord, the dispute was vis-a-vis the seniority, inter-se seniority.
Dispute is, yes, we know. But then the things boil down, whether you actually had that relaxation in your favor so as to be entitled to become a lecturer.
My lord, the facts in the judgment would suggest, my lord, there was no act of any mala fide or any,
Doesn't matter. We are asking you, where is the relaxation order?
that perhaps, my lord, the APSC would.
Why? So your case, your appeal,
That
show us that order of
relaxation
relaxation.
order is not there.
Is not there. There is no relaxation. How could your basic, fundamentally, your appointment is wrong.
My lord, my lord, I had served for 12 years now, my lord.
Immaterial. Alka Oja,
Faggot.
judgment of Alka Oja. There was a
If I may kindly-
large number of motor transport inspectors who worked for 5 years
Yes, my lord.
and they were sent home.
There's a
Not
later judgment, if I can kindly place, my lord.
Please do that.
Similar circumstances, my lord.
Yes.
Vikas Pratap, 2013-14 SCC, my lord,
Hmm.
494.
Yes.
I'll read from paragraph 20, my lords.
Hmm.
Paragraph 20, 502, my lords, page number.
No, that is on question answers.
Question answers. my lords,
Evaluation.
They had
No,
spent some
no.
time under interim orders, my lords, and there was no allegation of any mala fide.
That,
So the
you
learning-
see, evaluation process, equity can work
My lords.
because the candidates have worked. But on qualification, give us one judgment on qualification.
No, I'm qualified. There's no
Qualification means you're not qualified on aspect of age.
only age, my lord.
So,
Otherwise,
yes.
I'm qualified. As per the advertisement. I
Qualified
have-
on aspect of age.
My lord.
You did not have that. You were not having that age. You were fundamentally challenged in this matter.
My lord.
Not
Because,
having not within the age limit. How could you have applied even? You had that management in your mind, in your hand. But yes, we'll manage everything, get into this job.
But that does not reflect in the.
That is
judgment.
reflected on the face of it.
My lord, if
That
I may
without there being an order of relaxation, you have managed to get hold of that job, that post.
My lords, but that question has to be posed to the APSC and the government, my lord.
Why should we? We are in red jurisdiction. We are examining your post. Is the rate of covenant? Oh, yes.
No, it's not.
So, and we are asking you, where is your relaxation order.
If I may read out two paragraphs.
Read whatever you want.
No,
We have read the order.
no, sir.
You want to take the trouble, read, do that.
Just two paragraphs. Sir.
You're trying to
Like
kill
that.
time till Ms. Chaudhary turns up. We are fine with it.
My
We'll give you that opportunity.
lord.
Hmm.
So I'm reading paragraph 21, my lord. Shri Rao would submit that the case of the appellants requires sympathetic consideration
Hmm.
by this court, since the appointment of the appellants on the basis of,
You are asking this court to exercise power of age relaxation now.
my lord, I'm willing to give up on the aspect of seniority vis-a-vis my
No,
learned
there's
friend.
no question how you can hold the post, sir. There's this question. You are reading which para
Para 21, my lord,
of
page 502, my lord, of the judgment which I've just provided.
a judgment? Oh, that judgment.
2013-14 SCC, my lord.
Yes, read.
Shri Rao would submit that the case of these appellants requires sympathetic consideration by this court, since the appointments of the appellants on the basis of properly conducted competitive examination cannot be said to have been affected by any malpractice or any other extraneous consideration or misrepresentation on their part. The ouster of 26 appellants from service after
On
having
account of a revolution process which took place subsequently. In that scenario, there are n number of judgments of Supreme Court wherein supernumerary posts have been created.
Yes.
For those who have gotten after the, or who are ousted because of that process.
So the ratio, what I could gather, my lord,
Is
if
good.
there is no misrepresentation
No
or any fraud,
ratio as such. It is equity which has worked. In your case, there is no question of equity because there is, supposing there was an illegal order of age relaxation, maybe we could have been persuaded to consider your case. But herein there is no order as such. It's only a reference which is made. Thereafter, though no order is passed and you are allowed to appear, you are
reference
allowed
was
to.
made, my lord, but I sat in a proper, my lord, recruitment process before the
There's
APSC
nothing
and
proper,
got
Mr.
selected.
Counsel. There's nothing proper because you could
Except
not have
the
been allowed.
Age relaxation.
You could not have been allowed to attend that
Mm.
examination.
My lord, I've been working for the last 13 years, my lord. So,
That doesn't save you,
and,
sir.
and I have left my earlier regular post as a clerk.
That you took that risk. You were having that bravado. All right, it'll come around, don't bother.
My lord, on grounds of equity, at least I
How can there be an equity in a grossly illegal action?
because there is no malpractice on my part, my lord.
Oh, there is a malpractice on the face of it. How did you dare sit in that examination? Or how were you allowed to sit in the examination without
applied-
there being any order of age relaxation?
I applied through proper channel, my lord. That was accepted by the authorities. And there was no, I didn't, my lord, misrepresent my age. Age was already known to the authorities.
Yes, so the authorities acted illegally.
But there is no
Then
foul
that
play on
doesn't
my
save your
part.
case, sir. That doesn't save your case.
I understand, my lord, there may be some irregularity
Some
at
means
best.
what? Irregularity is illegality writ large on the face of the record.
my lord. Well, I would request my lords to.
Now we are sitting, all right.
And my lords, on the aspect of the seniority, my lord,
Seniority will come in picture later,
later, my lord.
if at all,
Because in
your job is.
Vikas Pratap, what had happened, my lord, those people had already rendered some years of service under the interim protection of the court, my lord.
Read Alka Oja nikal ke do. And Amilal, but that is the judgment on which this, your writ petition was this, their writ petition was allowed.
Yes.
That is the law relating to relaxation of age, public interest.
Yes.
What was the public interest in relaxing your age?
Otherwise, I'm a PhD, my lords. in
Maybe
LLM.
you may be having a double PhD LLM from London, what, whatever it may be. What was the public interest you want?
My lords, the honorable single judge, my lord,
Yes.
he went on a roving and a fishing inquiry, my lord.
Oh,
The
is that so?
question was only seniority, my lord.
That only asked you, where is the order of relaxation? And you stuttered there.
That is not there, my lord. The order of relaxation is not there. What we are claiming, that it has,
You have been allowed to.
it is deemed to have been relaxed.
No, there can't be any deeming power for a relaxation of age. There has to be a specific order on the reasons which have been set out in the rules or OM.
My lord. And
Fair treatment in the recruitment process.
Yes.
What is fair in this?
Yes.
You are allowing a man of 44 years to compete against young talent What is fair in that? By giving him the undue benefit of age relaxation.
And one more aspect, my lord, if I may point out, the
Yes.
OM, my lords, which
Mm.
my learned friend is relying on, and which was relied by the writ petitioner,
Mm.
that has been set aside by this honorable court.
Mm.
And now the OM goes back to the 1951 OM,
Yes.
which is framed under Article 309.
Mm. Mm.
I'll hand over a copy, my lord. Under-
What does that rule read? Read that also. Read.
Oh.
What is the criterion?
Sorry, welcome. That's there. I'll read.
Hmm? That must be a part of record.
No, my lord. Yeah.
Leonard Single Judge has relied upon 1951 only.
Yes.
Read para 6.
Yes.
So that still holds field.
Yes.
Yes.
My lord, learned single judges relied on these two words, my lord.
1951.
Yes. I'll hand over.
Public interest and fair treatment.
Fair.
So what is the public interest in this? Hmm.
My senior and senior.
Yeah, here is.
I'm sorry, my lord.
One question only, Mr. Chaudhary.
Yes, my lord.
Where is the order of age relaxation?
My lord.
Where is the order of age relaxation?
My lord,
Is that there is a deemed relaxation?
I'll try to attempt an answer, my lord. If your
Don't venture into that argument. Deemed. There's
No,
nothing
no,
deemed in this.
I'm not saying that, my lord. If your lordships will kindly come to, heavy order, heavy measure. 1 second, my lord. Yes.
Take it.
Uh,
Relax, catch your breath and then start.
Yes,
Sit down for a moment.
it's okay. my lord.
No, we are serious.
Yes.
Catch your breath for a minute.
No, it's okay, man. I can start.
Okay.
Now, if your lordships would kindly come to page number 55, my lord.
We are asking you a simple question. Show us the order of age relaxation.
No, that is what I'm.
Hmm.
Sorry, page 56, my lord.
Yes, please.
I am enclosing herewith.
That is reproduced in the order of single judge.
Yes.
Hmm.
I am
Yes.
enclosing herewith a photostat copy of application dated 11/6/09
Hmm.
along with his enclosures, which is self-explanatory.
Hmm.
I am directed to say that Government into Education Higher Department is placed to refer
Hmm.
the condonation of overage up to 45 years in this.
So it is a reference made.
Yes.
All right, reference made, but when did the government exercise the power?
Now, my lord will kindly come to that.
What was this reference made in
Yes.
reference?
My
Mr.
lord will
Chaudhary?
kindly come to
This
page-
reference was made by relying on what?
No, my lord, based on a circular of the government.
Which one? Which one?
Page 103, my lord.
This letter doesn't refer to any such OM of the government, I'm
Yes.
sure. We are
My
sure.
lord will kindly come to page 103.
Yes, please.
Office memorandum dated 27th of March 2018. Now,
We are told that this office
section
memorandum,
3,
we were told by your assistant counsel
yes,
that this has been struck down.
yes, in the
Yes.
meanwhile.
All right, so in 1951,
Now,
it boils down to 1951.
yes, my lord, please
Yes.
come to para 4. Why they did it, that's what I'm trying to show, my lord.
Yes.
In case in which recruitment is made through Assam Public Service Commission, the commission should be consulted before the rules are relaxed in the following manner.
Mm.
The appointing authority, when approached by a candidate for granting exemption, if it is satisfied that the case deserves consideration, shall refer the case to the Assam Public Service Commission to consider it on merits, notwithstanding the candidate exceeding the age limit, and commission shall then not reject the candidate merely on the ground of his being overage. The commission shall make his final recommendation having regard to the fact of the candidate being overage. Lordship may kindly skip the whole sentence and will state whether in its opinion this make the candidate unsuitable for appointment in
Ms. Chaudhary,
question.
this OM having been struck down,
Yes.
what is the use of
Now,
this OM?
now my lord will kindly
51.
come to the 51 OM.
Yes, we are on that.
I'm coming.
Yes.
Copy to Dila. What is it? Dita hai, sir, was it? This. Lordship has gone to 51. Yes. In fact, my lord, the purpose of striking down the subsequent one being this is
It
a
was not
309.
under 309.
So it is, we could not have it.
Executive instruction.
Yes. In pursuance of the provisions of Article 309 of the Constitution of India, the Governor of Assam is pleased to make the following general rule regarding relaxation of age limit for recruitment to civil services or civil post in connection with the affairs of the state of Assam. Notwithstanding anything to the contrary in the rules regulating the maximum or minimum age of recruitment to a service
or post in connection with the affairs of the state. The age limit may be relaxed in favor of any candidate or class of candidate only if in cases in which the appointing authority is the governor, or in other cases, the head of the department consider is necessary in the
interest of fair dealing and public interest. So what is the interest of fair dealing and public interest in this case, assuming your argument that there is a deemed kind of relaxation?
No, I'm not saying that.
So
my
then
lord.
what is the interest?
There are a comedy of errors, to be honest, my lord.
No, this is nothing, sir. This is something which the employee, your client knew that he will manage things.
No, my lord.
Otherwise, he would
my
have
lord.
that kind of bravado
No.
in resigning from the earlier post.
No, my lord. If your lordship will kindly look at the advertisement, my lord.
Yes.
Advertisement is at page 39.
Yes.
38.
Yes.
If your lordship will kindly come to page 42. The learned single judge says, I do not have teaching experience. It's an entry-level post. Page 42, my lord, educational qualification. LLM with 55% marks with net slate or PhD. So this is the requirement, my lord. LLM with 55% marks with a net slate or PhD. I'm PhD. So my lord, this is the requirement. So my lord, learned single judge emphasis was on that I do not have teaching experience. I was a clerk. My lord, how is it a case, my lord, a clerk cannot aspire for a higher position?
There's no dispute about that.
Therefore, my
Very,
lord,
very well. That's
so my lord, this is
laudable
the
effort.
requirement.
Question here is the clerk who is almost 45 years, 44 years.
44 years, 11 months.
He can work to the detriment of younger talent.
No, my lord,
by managing to get the age
what
relaxed.
is my fault, my lord?
It's your fault that you managed to get into the examination without there being any order of age relaxation.
No, my lord, it is not even the case of the petitioner also that there is any malafide, my lord.
Forget about the malafide, sir. Where is the question of you being
allowed
to attempt the examination?
My lord, I am relying upon the vision
The
of
judgment we have
Vikas
seen.
Pratap Singh's case, my lord.
Alka Oja, sir.
Alka
Oja.
No, my lord, Alka Oja.
Singh is a different case. In that scenario wherein there is a revolution or re-evaluation of mark sheets, there are n number of judgments wherein supernumerary posts are created for the candidates who are ousted because of the fresh evaluation
I am
process.
retiring in December.
Yes,
Sorry,
in-
January 2024. And my lord will kindly see, in this case, my lord, when candidate is not at fault, then normally Honorable Supreme Court has said, my lord.
There's no question of candidate being at fault. Candidate was not qualified for the post on account of being within that age.
No, my lord, the petitioner's perspective is his concern with the seniority.
Yes.
My lord, yesterday we have taken instruction from our client that we are even prepared to forego our seniority also, my lord.
Whether we can.
In fact, in Vikas Pratap Singh, the same thing was done, my lord.
Ms. Chaudhary, we close our eyes on this? They are asking us to do that.
My lord,
There is no order of age relaxation,
my lord,
sir. How
equitable,
could he have been allowed to sit in?
no equitable concept. My lord, what do I do, my lord? My lord, what is my fault? I have applied in the proper format. I have taken no objection from my employer.
You are an educated man. You are aspiring for becoming a lecturer in law. You sit in an examination without there being any order of age relaxation. That by itself is sufficient to not suit you.
No, my lord, even government of Assam has regularized everything, my lord. Kindly see, my lord, after my lord, at page 55, even I was given pay protection, page 55, my lord. So after all this, my lord,
Everyone was having eyes closed. That means the court should also work in the same manner.
I'm not saying that.
So then-
Please come to page 55, my lord. I am directed to say Government of Assam in the Education Higher Department is pleased to allow protection of pay of Dr. Asutosh Kundu of his past service to the fixed day pay of the incumbent concerned at the initial stage of pay of the revised UGC scale of pay of rupees so and so only joining as a whole-time lecturer in BRM Law College with effect from so and so under the provisions of FR 22-2. This is issued with the concurrence of the Finance Department. Even Government of Assam has taken note of my past service also, my lord. Pay protection has been given. My lord, as far as I am concerned, I have applied. I am a innocuous applicant, my lord. My case was forwarded. My lord will kindly see. I have taken. If your lordship will kindly permit me, my lord. Page 46.
What is the stand of the commission, please? Who's there for the commission? Commission is a party.
Yes. They file affidavit also. my lord.
Who is there for the commission? APSC.
Government one I need.
Let's have the stand of the commission then.
Page 112.
Commission's affidavit, yes, yes.
Affidavit, what does the
Yes, my
council have
lord,
to
page
say?
114 and 115.
Hmm.
Para 9, my lord. Before that, para, my lord, 6 at page 113. That with regard to the statement made in para 4 of the writ petition, it is replied that a total of 35 candidates, including the petitioner, applied for the post. However, only 4 candidates were found to be eligible and called for viva voce, but only 3 candidates comprising petitioner, respondent number 7 and 8 appeared in the interview conducted by the commission with the help of expert deputed by the government. Thereafter, a select list of 3 candidates was prepared and communicated
reading
to the
page?
government by later dated so and so,
Page 114.
114, my lord.
Hmm.
Petitioner appeared in the interview conducted by the commission with the help of the expert deputed by the government. Thereafter, a select list of 3 candidates was prepared and communicated to the government in the education, higher education department by later dated so and so, wherein respondent number 7, the petitioner and respondent number 1 were placed at serial number 1, 2, and 3 respectively on the basis of the overall merit and performance in the viva voce. Then my lord may kindly come to para 9. That with regard to the statement made in para 7 of the writ petition, it is replied that allegations are baseless. It is not eligibility criteria laid down by UGC. Rather, it is the terms and conditions of the advertisement which stand as the checkpoint in determining the eligibility of a candidate. The petitioner having participated in the same selection under the terms and conditions of the advertisement applicable to all concerned candidates.
Call the APSC council.
Yes.
Who would be there?
I'll call the
Uh,
Mr. Samuel.
If you re-notify on council representing the APSC is not available when the matter was taken up for hearing, re-notify on. Yes, APSC, what is your stand? He is not even aware which matter is called.
Looks like he's not.
Lost. And appearing for the APSC, so and so appearing for the APSC. Submit that he needs some time to complete his instructions and reconstruct the record. Re-notify on 19th September.
Deep level.